something I want to put in the record that would be a dispute with what you said about New Jersey, but already got a long statement, so I'm not going to go into that at this point. I'm going to support Judge Slaughter's nomination, so I want to speak about Mr. Mathis. The Tennessee senators worked to find a nominee who they could support. They put forward Judge Camille McMullen, a state court appellate judge who had been appointed by a Democratic governor. Unfortunately, this administration refused to work with them, voting to move Mr. Mathis' nomination would condone the administration's process in this case. That process caused the White House to miss out on a valuable feedback from Tennessee senators who know the legal community in that state. When I was chairman, I made sure the White House had meaningful consultations with members before moving forward. The senators have valid concerns about Mr. Mathis' lack of federal appellate experience and his lack of attention to detail. He made an unusually high number of mistakes in failing to follow the Sixth Circuit rules. Some of those mistakes might be small, but the people of Tennessee aren't going to see it as a little thing if details get missed in deciding their cases. Some have also suggested Mr. Mathis may be moderate on the bench, but he is a fairly junior attorney with a short record. He hasn't worked on cases involving major constitutional issues. Unlike the candidate proposed by the Tennessee senators, he has no body of judicial opinions to review. One thing that we can look at is evidence of his judicial philosophy is the article he wrote in law school. In it, he advocated for federal courts to adopt a new standard for habeas court cases. As Senator Hawley explained at his hearing, that theory of habeas review is radically outside of the mainstream, so his scholarship doesn't support the claim that he would be a moderate. Because of these concerns, I'll be voting no. Turning to the bills that are on the agenda today, so I won't speak again when these bills come up. I'm a co-sponsor of the Earn It Act. This bill makes an important step in holding online service providers accountable for very horrific spread of child sexual abuse material. I've long been a supporter of victims' rights and have fought for efforts that stop the spread of child sexual abuse material. In 2018, I co-sponsored the Stop Enabling Sex Trafficker legislation, commonly known as SISTA, which is designed to hold website operators accountable when they knowingly facilitate sex trafficking. After news reports emerged of sexual abuse of young amateur athletes in 2017, our committee, during my chairmanship, convened a hearing on this subject. I later worked with my colleagues on bipartisan legislation that would make it mandatory for instructors, coaches, and others who work with young athletes to report cases of child sexual abuse to the authorities. I led our committee in reporting this bill, known as the Protecting Young Victims from Sexual Abuse Act, to the full Senate and was later enacted. It's important to find ways to stop the spread of exploitative and sexual material, and this legislation does just that. This common sense bill received unanimous bipartisan support in the Judiciary Committee last Congress, and it's time that we get it on the books to prevent more child exploitation. Eliminating limits to Justice for Child Sex Abuse Victims Act of 2021 will also be considered today. This bill would enable survivors who were victims of over a dozen federal child sex abuse offenses to seek civil damages in federal courts, no matter how long it has taken the survivor to process and disclose the abuse he or she suffered. Delayed disclosure has historically impacted survivors' path to the justice that they deserve. We can't deter children in any way from speaking out against their abusers. We know from the Larry Nassar case and many other tragic examples that it can take years for survivors to muster up the courage to come forward. This bill sends a clear message to victims of these horrendous crimes that we see, we hear, and we support you. Now I'm going to go to something that the Justice Department is sick and tired of me talking about, but I'm not talking about it. I'd like also to discuss examples of the Justice Department's failure to respond to this committee's oversight request. On February 3 last week, the Justice Department purported to respond to 5 of my oversight letters in a single letter. The department also noted that since January 20th, 2021, I have, quote, written or joined approximately 50 letters to the department, representing about 1/3 of all the letters the department receives from members of the United States Senate, end of quote. Now, I doubt that Garland said that as a compliment. In that letter, the department noted that I provided a binder of unanswered letters to the Attorney General Garland during his confirmation, and I simply did that so he wouldn't be blamed for a lot of things that the Trump administration didn't respond to. The department noted that it responded to those letters. Now, in that case, the department is dead wrong. My staff made clear to the department last year that its so-called responses included non-responsive letters that I've had for years. The department essentially reissued the same letters. Second, new response letters that failed to fully answer the questions posed. You can put words on a piece of paper, that doesn't mean you're responsive. And third and last, the department failed to provide a single page of responsive records. As to the 5 letters the department said it responded to in that single letter, they failed there as well. As part of my and Senator Johnson's ongoing investigation into the Biden family's foreign business deals, we asked for FISA information on Patrick Ho. You've heard me talk about Patrick Ho before. He was connected to the Chinese government's intelligence services. Hunter Biden reportedly represented him for $1 million. The department confirmed in federal court. Now, let me say that again. The department confirmed in federal court that it has FISA information on Patrick Ho. But the department wrote a letter to me and Senator Johnson saying that it couldn't confirm the same. The department again refused to explain why Attorney General won't say whether Nicholas McQuaid is recused from Hunter Biden's criminal case. Yet the department has publicly confirmed that other employees are not involved in other criminal cases. The department again refused to answer about Mueller team wiping their government phones data. However, after pulling teeth to get documents from the department, it provided records to me. Unfortunately, those records were filled with improper FOIA redactions, and they didn't include the necessary spreadsheets. And I also want to know if career employees were consulted when the Biden administration said it's very weak crime policy, because if career employees weren't, then it would indicate possible political considerations infected the process. No answer on that question. As to my letter on COVID-19 and nursing home investigations, the department is hiding behind the policy that it doesn't comment on ongoing investigations. All we know, as we all know, the department can speak to ongoing investigations if they're in the public interest. So the Biden Justice Department has essentially taken the position that COVID-19 and nursing home deaths aren't in the public interest. Now, simply put, the department conduct is a complete embarrassment. Their conduct is a slap in the face to this committee. So Chairman Durbin, say it again to this, this committee must assert its constitutional oversight authority on the Justice Department. Thank you very much.